As part of your proxy statement filed with the SEC, you will include a beneficial ownership table that discloses what your directors and officers own for your own company stock today on ZippyPoint. I'm Brock Romanek. I'm a big fan of yous. So before I bring on Roland Kelly, bringing his in-house perspective, his in-house lens, to explain how to fill out the beneficial ownership table, this table in more detail, let's run down some of the basics. The purpose. Why does the SEC require this information be disclosed? It gives shareholders a sense of how much of an equity stake that your directors and your officers have in the game. Do they have skin in the game? Do they have skin in the game? Do they have skin in the game? That in turn will help shareholders make their voting decisions for the items to be voted upon at the annual shareholders meeting. The legal requirements. Under item 6D of Schedule 14A, companies are required to provide a beneficial ownership table in their proxies, which is incorporated by reference into the Form 10-K under item 12 of that form. Item 403B of Regulation SK is the regulation that spells out what the table should look like, what it requires. It requires disclosures of the equity securities beneficially owned by directors, director nominees, and named executive officers, as well as a total of all these people, including other executive officers too, as a group. The number of securities listed in this table must include the right to acquire beneficial ownership of any securities within 60 days. For this calculation, you'll be following Rule 13D3. That's a beneficial ownership rule. Now, there are two beneficial ownership tables. There's this one for the directors and officers, and there's one for 5% shareholders, which I discussed separately in a separate Vid-Guide, a link to which is below. But these two tables can be combined into one in your proxy, but typically they're split into two, and as you'll hear soon, they'll actually be in different sections of the proxy. So where in the proxy can you find this beneficial ownership table? It varies since item 6D of Schedule 14A doesn't dictate its placement. It's mostly found in the middle or towards the back of the proxy statement, but it's up to the company. They have the discretion to put it where they want. In fact, the caption for the table varies. It's not a specific mandated title. So it might be securities ownership by directors and executive officers. It might simply be stock ownership. It might be voting securities and principal holders. It varies quite a bit. And you can modify the table a little bit. In item 403, a form of the table is specifically provided. The format of the table should not be varied too much from what is in this item. You are, however, permitted to add additional columns to help provide additional information, additional gloss. So that's the variance you can provide if you want. But otherwise, the table should be as it is in item 403. Instruction 2 of item 403 suggests the use of extra columns to help explain the numbers in column 3 regarding whether a beneficial owner has sole voting power, shared voting power, sole investment power, or shared investment power. But often this is done in the footnotes. It's not done through additional columns. You might have other types of extra columns, perhaps one to show the number of shares subject to exercisable options to simplify the table by not having so many footnotes, or perhaps another column for another type of security held by some of the insiders that also has a right to acquire the stock within 60 days, the beneficial ownership rule, like director deferred stock units. There's typically quite a few footnotes to this table. This beneficial ownership table tends to have a lot of footnotes. It's not uncommon for a company to have as many footnotes as there are lines in the table, if not more. Item 403 requires you to disclose any options or other rights that could result in beneficial ownership within 60 days, 2 months. There will be footnotes to explain that some of the securities are not held by an insider directly, but they're held indirectly through a foundation or another affiliate of the insider. There often are numerous footnotes to break out explanations of the various types of securities included under the many different compensation plans that these types of directors and officers tend to participate in. Which directors and officers get included? Under item 403B, all of the directors, director nominees, and named executive officers must be included by name. The named executive officers, I have a separate Vid-Guide explaining how you determine those, but typically company has anywhere between 5 to 7 to 9, but typically around 5. That's usually the minimum. These directors and executive officers are each specifically identified in the table in column 2, along with their stock holdings in the company in column 3. The table should include any director who will continue to serve in office any director that is up for re-election, any new director nominee, and any director that is not being renominated. So that's a little bit odd. Any director that is not being renominated will not be on the slate for this proxy statement is still included in this table as noted in this CorpFin staff interpretation. This can be a little confusing. As a result, the only directors that can be excluded are the ones that have terminated service already, including death, before the date of the proxy statement. This means that you even include a new director who joins a board before the proxy statement is filed, but after the last practicable date used in the table. All NEOs, the named executive officers, must be included in the table, even if they have left the company since the end of the company's fiscal year end, and for that matter, even if they left the company before the end of the last fiscal year, but still met the item 402A3 definition of named executive officer. They're one of the NEOs. This requirement is a bit strange because it's not clear if shareholders care about how much a departed officer owns in a former employer, and tracking down a departed officer to ascertain their holdings can be difficult, can be a challenge, particularly if that person was fired. The only exception is that an NEO who has died can be omitted from the table, according to this CorpFin staff interpretation. And now we're going to bring on Roland. Our guest today is someone that I've known for a couple of decades, Roland Kelly. He's been in-house for over 20 years, having recently made a switch to Velocity Financial to serve as their general counsel and corporate secretary after a long career at Jefferies Financial Group, where he served as the right hand to the general counsel with the title of managing director, associate general counsel, and assistant secretary. Roland has a unique background because Jefferies also had some major subsidiaries, one of which Roland served as the de facto chief legal officer and chief compliance officer. I'm Brock Romanek, today on Zippy Point.
Quick Zips by Zippy Point.
Quick and dirty. So Roland, for the beneficial ownership table relating to directors and officers, why don't we start with just the determination date? How do you pick that for when you're going to make your calculations?
Well, Brock,
Proxy.
Brock, the rule says the latest practicable date. Early in my career, what I deemed to be, latest practicable was usually 30 days before we were actually going to file the proxy statement. But these days, because I have access to so much information so timely, I can really have it almost the day before we actually file the proxy statement.
Wow.
So it's just a matter of how accessible are the numbers. Sometimes, of course, too, if you know that a number is going to change, for instance, if you just happen to have a dividend reinvestment plan and you have a dividend payment, you'll want to make sure that you capture that. So you may move the date back. If somebody sells or buys, you may want to move the date in order to reflect that. And then what we have done in the past, we'll have one date set forth for the table and footnote that such and such person had a transaction on this particular date, and that's included in the table above.
So I know the math for these tables can be sometimes a little bit confusing. What's required to be in the numerators and denominators for directors and officers individually?
Yeah, so the numerator is, the easiest is common shares. That's obviously in the numerator, but you also have to take a look at any type of instrument that has voting rights, any type of instrument that you have investment power over, as well as, for instance, options, any type of security you can acquire within 60 days. So options, warrants, convertible notes. So all those have to be in the numerator. And when I say things like, voting power, for instance, we may issue restricted stock. And so an executive may be able to vote those shares, but they don't have investment power over those shares because they haven't invested yet. On the other end of the spectrum, we may have restricted stock units that the executive may have an economic ownership over, but because the executive has neither voting power nor investment power, they wouldn't show up in that table, in the numerator. Now in the denominator would be your total shares outstanding as of the date that your table reflects, plus you need to add into the denominator any of those shares that you've added to the numerator that you have a right to acquire within 60 days that are not already reflected in outstanding.
So what about diligence? Do you go beyond your Form 4s to look to double check your numbers?
Yeah, I think really good practice is taking a look at what's been obviously publicly reported on the Form 4s, and then also your D&O questionnaires, your directors and officers questionnaires. Oftentimes, as part of those, the executive will give you either the brokerage account or brokerage contact information. And if you really want to cross your T's and dot your I's, lob a call into the broker and say, this particular executive of our company shows this many shares, can you confirm that? And brokers, once you've set up a rapport with them, are very happy just to answer your question, and you can check the box. I've done my diligence on this. Obviously, as a company that issues shares, you can talk to your own transfer agent. Transfer agents oftentimes will have in book entry or even certificated form for some of the older individuals. You can talk to your transfer agent and get some of the information as well to back up what you're putting in your beneficial ownership table.
Do you maintain a spreadsheet for all your executive officers and directors for their broker email addresses and phone numbers and all, their contact information?
Yeah, I do that. I'm kind of old school that way. It's something I inherited from the person before me 20 years ago, and it's something I continue to do. So I have my spreadsheet with the different types of securities that somebody may own, restricted stock, what I call brokerage stock, which is just, common stock outstanding that's held in a brokerage account, book entry shares, restricted stock units, options, warrants, deferred shares, RSUs. And then I also have brokerage information. So anytime there's activity that the transfer agent has to take shares and deliver it, I'll make sure I know where the shares are going to. So I'll annually update that and confirm that the broker is still there and the executive is still using that same brokerage firm.
And in the spreadsheet, are you listing out, sole versus shared investment power and voting power? And
good question.
Those categories?
Yeah, so I will have a column. So for us, some of the executives will use family trusts, in which case shares are held indirectly. Profit sharing plan, shares are held indirectly. So I will have separate columns whenever the shares are held indirectly. If a spouse or significant other owns the shares and they live in the same household, I'll have a separate column and just label it so that I have all that information at my fingertips.
And what about an officer who has left a company during the fiscal year? Sometimes I know that can be challenging, particularly for a sort of acrimonious departure, to get final data from that person. And you gotta just do your best you can, from my own experience, that, try to reach out to that person, and they might not want to play ball with you because, and it's understandable, they're done with the company.
Right. The best you can do is, if you're really concerned that the information may not be correct, is you can just reflect based on, information provided, or, basically just note without creating controversy, just note to the best of your ability that the shares are what you believe they are.
So let's talk about disclosure. So you have to disclose ownership for the directors and officers as a group. And that math is a little bit different when you're talking about, when you total that up. Can you talk about how the numerators and denominators work there?
Yeah, it is very confusing because, you'll take a look at the beneficial ownership table, and at the bottom it'll say, total directors and executive officers, and it'll say 15. Oftentimes people will put, the number of individuals, but then if you look, there's only, 10 people listed. That's because you may have executive officers that you have to include, like a controller that may not be a named executive officer. So they won't necessarily be in the actual table itself. So you do have to include all the executive officers, and that's a determination made by the board of directors under the securities laws. And so it's typically the people who are filing the Section 16 reports. And so even though, again, they're not in the table, they are included as officers on that total. So you do have to include in that number the shares that they hold, as well as any of the shares that could be acquired within 60 days have to be included in both the numerator and the denominator.
Right. So anyone who's not sophisticated, meaning they don't know the SEC's rules, might look at the table, look at the total comp for each individual person in the table, total it up and say, hey, the total number at the bottom here doesn't equal really the total, and what is this company doing? But that's just the nature of the beast. That's the nature of these regulations.
It is, and it's surprising every year somebody, it's a good sign too. Somebody's actually reading the proxy and doing the math and bringing to your attention that the numbers don't add up, and you just explain to them how the math works.
I guess that's a good way to know that no one's ever read your proxy, because you've never gotten that question. I'm going to go ahead and bring up a sample here when we talk about footnotes. So here, this is Primerica's proxy statement. This March 1st date, that's their latest practicable date. That's their determination date, right up at the top. And then the way they've decided to format the table, I like the way this works, is that they have the names of the owners, the directors and officers, and then their total numbers, the percentage. If it's less than 1%, you can just use an asterisk. And then their footnotes are right to the right of each person, which is, not typical. I think the old school way is to include a footnote like a footnote, but this obviously is much more usable and readable. I like the way they're doing that. And then here's another example, old school. This one's McDonald's. And again, here's their determination date and their table. And then let's go down the footnotes. Why don't you spend a minute, Roland, if you don't mind, talking to us about footnotes and what commonly goes in there. As you can see, there's often lots of footnotes. This
right.
is 7 footnotes, but you usually might have a lot more than that.
Right, and I do like where the issuer included the footnotes in the corresponding table or in the corresponding row. That's great if you only have very small footnotes, such as shares that are indirectly owned, or the number includes a certain amount of options. But unfortunately, what you'll have, at least in my experience, is you'll have extremely detailed footnotes that have multiple sentences describing X number of shares are directly owned, Y number of shares are indirectly owned by the executive's significant other, or a family member who lives in the household. A certain number of shares underlie options that are exercisable within 60 days. Another number of shares are issuable upon distribution of restricted stock units. Whether or not they have voting power over shares, or shares that are held in a profit sharing plan. These are all footnotes that we've used in the past, and oftentimes you'll see other issuers use them as well. So really isn't conducive to adding into a row next to the number of shares owned. But unfortunately, it makes for lots of footnotes underneath the beneficial ownership table. And also something that we've done is, especially with restricted stock units, which are basically just deferred credits to receive a common stock sometime in the future, where they aren't included in the table as beneficially owned because they don't have voting rights and they don't have investment power, is what we've done for some executives is we'll have a footnote specifically for them saying that assuming the expiration of all vesting and deferral dates, this particular executive would own 5 million shares of our stock, representing 3% of the outstanding. And oftentimes that's materially different than what is disclosed in the table itself. And it's something that we found is a good disclosure because it shows investors that the executive owns more shares and has more skin in the game than what the table actually shows.
But what about the placement of this table within the proxy statement? Where do you like to put it?
Yeah, as you mentioned, there's no requirement to put it in any particular place. Years ago, I used to put it pretty much close to the front of the proxy, thinking that, that's, information that investors find really important. But as the focus of the proxy statement has really shifted towards a compensation document or compensation disclosure document, I found a lot of the corporate information, other than governance, all the other corporate information has gone towards the back of the document. And that's where we currently put the beneficial ownership table, towards the back of the document.
Yeah, that's where it is in these two examples we've seen. So for fixing an error, which can happen often when you're trying to collect numbers from your directors and officers, there's not much you can do because this is a proxy statement. It's not like an 8K where you can file an amendment. So the only way to really correct it is in your 10K, which will be filed subsequent. No, this 10K is filed before the proxy. I guess you can file an amendment to your 10K, but you don't often see that done because any errors, the numbers here are usually pretty minor and not material to the company itself. And hopefully they're not even material to the number that you disclose for the officer or director. If it was material to the director, an individual director or officer's ownership, then I think you would have to do something. But I don't see companies filing additional soliciting material to get the word out before the shareholders vote at the annual meeting. So last question, Roland, where does this table fall on your fun scale between 1 and 10?
Fun scale?
The fun scale.
Actually, it's a 9 for me, actually. I love numbers. Nice. I love spreadsheets, even though I'm not a spreadsheet expert, but I just love numbers and spreadsheets. And kind of control as well. I'm the one at the company who knows how to do this. I'm the resident expert, and for me, it's a 9, unfortunately.
Thank you very much.